Good afternoon, and thank you for joining today's CCI Gonghoshi Chateau Condo Talk webinar. My name is Maria Durden. I'm a partner at Simpson Weigel Law and the chair of the Condo Practice Group. I'm also currently the acting president of the Gonghoshi chapter and the co-chair of the Education Committee. Condo Talk was created to provide free, short, informative, and practical-based solution webinars for condo owners, directors, and anyone practicing in the condominium industry. Today's Condo Talk, expansion of the Condominium Authority Tribunal, the CAT, will review the vision and impetus of the CAT, a couple CAT decisions on record disputes, and discuss the future considerations with the recent expansion of the CAT. Today, our sponsors are Elia Associates, Progress Property Management, Wilson Blanchard, and Common Ground Condo Law. Thank you so much to the sponsors for supporting our chapter. We have an excellent lineup of speakers. Chris Jaglowitz, the principal at Common Ground Condo Law, also sits on the CCI Golden Horseshoe Chapter Legislative Committee. Michelle Joy is the General License Manager and Registered Condo Manager and the Director of Condo Management at Wilson Blanchard. And Victor Yee is a condo lawyer and litigator at Ely Associates, a law firm that specializes in condo law, and who has successfully represented clients at all levels of court in Ontario and various tribunals throughout the province, including the CAT, and in condo-related mediations and arbitrations. Welcome to the speakers. We'll start off with looking at the vision and impetus of the CAT. So up until October 1st, 2020, the CAT only looked at record disputes, but as of then, we have now seen an increase in disputes to pets, vehicles, parking, storage, and indemnification provisions. So quite more broad than it was before. Let's jump into this and see what we think about it, Chris.
Excellent. Thanks, Maria. And hi, everybody. Thanks for joining us today. Where I want to jump in is to take a step back to how about 2012 or so, back to the Condo Act review process, where government heard, after listening to condo unit owners, boards, and stakeholders, a little bit about what was working well for condominiums under the Condo Act and what was not working so well. And government heard conclusions from the working groups and the residents panels, and had concluded that the way in which condo disputes were not being dealt with in an economical, quick, or fair, or accessible way for condo boards, managers, and unit owners. And so one of the major recommendations that came out from that process was the conclusion that, well, records cases in the small claims court was difficult. Mediation and arbitration of simple rule enforcement cases was not working very well, and that court works very poorly for just about everybody in almost every situation, except for lawyers, of course. But beyond that, there needed to be change. And so from that, government had taken those things and had amended, as part of the 2015 amendments to the Condo Act, had created the Condominium Authority Tribunal. And the goal and the impetus behind that, of course, was to make condo dispute resolution a whole lot easier, more accessible, more affordable, simpler, and generally, of course, to have an expert body of decision makers who would not only assist the parties in resolving their disputes before an adjudicated decision needed to be made, but also to render those decisions when no settlement could be made, to make the decisions. And these are people that decide condo cases all day, every day. Whereas in the past, and the way it works now, of course, when you show up in Superior Court or in the Small Claims Court or in any other non-condo body, you've got sort of a non-expert panel of generalists or people or judges or decision makers that hear mostly other kinds of cases. They would need to learn about the condo law, they would hear the evidence and make the best decision they could based on the limits of their knowledge. And lawyers would spend a lot of time educating those decision makers about how cases ought to work in the condo law context, with the result being that in many cases we'd get good decisions, we could get some terrible decisions, and of course we could have some terrible fact scenarios that would make for terrible law that would affect future decisions. So government had decided, with the recommendation many stakeholder bodies, including some of the condo manager and condo associations like CCI and ACMO, to look at creating this kind of expert body to decide these cases, and that is the CAD. The CAD, of course, launched in 2017, and they began with a small jurisdiction of just hearing cases about records. And of course, those cases used to be in the small claims court, then were brought to the CAD to be decided there. I'm going to ask Vic to say a few words about that process in a second. And so that was 2017. Fast forward now to the summer of 2020, and the government has looked at the fact that with the COVID-19 pandemic and the major and just crushing backlog and overload of the court system, that it becomes increasingly important to get some of those cases, these rule enforcement cases and the pet cases and parking stuff, and get that out of Superior Court and get it into a different tribunal where those things could be handled, as I said, more cheaply, more quickly, with expert tribunals, more accessible, and so forth. And so as of October 1st, we can now, when I say we, I mean condo corporations and unit owners and mortgagees, can make application to the Condo Authority Tribunal for orders related to issues dealing with, as Maria said, parking, pets, storage, and indemnification, the recovery of costs related to those disputes. So it all sounds really good, but of course, one thing we'll talk about today are all of the nuances and the other things to think about. So with that, Maria, I'll send it back to you, and perhaps we'd have Victor give us a little bit about the CAT's, the record process there, or to Michelle, whatever you see fit.
Yeah, no, absolutely. So it's, you touched upon three terms. So quick resolutions, affordable, and by and parcel accessible. So that was the goal of the CAT. And expanding those areas of disputes so those other issues could also be resolved in the same manners as records. Maybe before we go to Vic, we can ask Michelle. So as a manager, whether you yourself or someone in your office has dealt with record disputes, how have you found it so far? Has the process been in quick resolutions, affordable and accessible? How has it played out? What's your experiences with this?
Yeah, so I would say that from my perspective, the CAT typically is accomplishing those three topics or three areas that Chris highlighted. It's certainly accessible. For the most part, they seem to have a pretty streamlined process to address the dispute. And of course, it's very affordable. So from a management perspective, I think that the records request process that they put in place and then the CAT handling those disputes when they do arise, I think overall, the concept and the process is great. And it's certainly, there's certainly some challenges that have come from it as well. And there's obviously some lessons from the management and board perspective that we can take from we call it early days. It's been almost 3 years now, but it doesn't feel like 3 years, but the early days, I guess we can call it. So from a management perspective, I think, it's really stressed the importance of accurate record keeping, which ultimately should have always been a goal of corporations. But we know with self-managed and transfers of documents from various boards and management companies, things get lost. But with this process in place now, we really, really have to make sure that we're doing accurate record keeping, and not just record keeping like of physical existing records, but I think the process, the CAT decisions and the records request process has really stressed the importance for boards that decisions must be made at duly called meetings. They must be accurately reflected. So I've seen it come up where a contentious decision is made or a decision that owners may not like. And there's a records request, and a board has made this decision via email or at someone's house over coffee, and minutes were not taken. So I think this process has taught us that when you're making really important decisions, you need to make sure that those are accurately reflected in your records, because you're going to be required to produce them. And if you can't produce them, you're going to face probably a fine, or there's going to be a decision from the CAT that's likely not going to go in favor of the corporation, because you should be keeping those records. Mm-hmm. Yeah, I would say I personally, thankfully, haven't had to deal with a cat case, but we have had some in our office. And again, I think the process, they have a pretty streamlined process of how to handle it. I will say that a lot of the time, the corporation does end up involving legal counsel. So at the end of the day, there are still legal costs on the corporation's end. So maybe not as affordable for the corporation as it is for the owner, but obviously much more affordable than going to the courts to handle this scenario.
Right. You mentioned that, it's been a couple of years, and they say when you're really enjoying what you're doing, time flies. So maybe that's indicative of that for you, Michelle. But you're right. Whenever there's a change, so here we had the creation of the CAT, it kind of forces corporations to look inward at themselves with respect to records, making sure your decisions are made at duly constituted board meetings, everything's documented, resolutions are passed. So now we'll talk a little bit further about how the processes, internal processes will change with respect to parking, pets, and indemnification with the expansion of the CAT. But before we go there, Vic, could you kind of comment on what is the process right now with respect to disputes? How do they proceed through the CAT?
Sure, thanks, Maria. So I've had I just checked, about 12 cases so far. 2 of them are currently ongoing, so I won't speak about those 2, obviously. But generally speaking, it's a 3-stage process. So it's going to be the same with the CAT expansion. It's going to be the first stage of negotiation, which is basically the parties themselves. So in a records dispute, it'd be the unit owner who wants the records and the condo corporation who either wants to disclose them or doesn't want to disclose them or discloses them in a limited fashion. They basically negotiate with each other directly. There's no involvement of the CAT members. It's just party-on-party negotiation, exchange offers to settle, and once the unit owner's made an offer to settle, the condo's made an offer to settle, unit owner can reject that offer to settle and then move it to stage 2. Stage 2 is mediation, and that's when a CAT member gets involved. So you get a member of the tribunal stepping into the online portal to try and facilitate a settlement, basically, between the 2 parties. Now, if that fails, and those members do try their hardest, if that fails, then the unit owner can request a stage 3 adjudication. And that's when a different CAT member, a different person from the CAT mediator, will step into the portal, take it over, and basically make a ruling. They will decide the dispute for the parties. So obviously, I think it is a shorter timeline. I think, Chris, you mentioned that it's a more efficient process, or should be a more efficient process, and it is by and large. The timelines that the CAT gives you are days or even just a couple of weeks. It's not like the courts where they would give you months to respond to a certain document with more documentation. It's quite literally a few days. I've had timelines as short as 2 days. I've had timelines, I think the longest was like 2 or 3 weeks. And that was already in an odd situation. But it is a little bit more efficient that way. It is, you get to a decision quicker and overall. It's also more accessible, as Chris also mentioned. Another goal is accessibility. It is a 24/7 system. You can access it on weekends. You can access it from the cottage while you're, sitting in the bath. You can do it from wherever with whatever you want, and you can basically jump into the system, type in whatever you need, upload whatever document you need, and not have to actually go to a courthouse, and actually do the work inside a courtroom or file it and swear it in a lawyer's office. For example, if it's an affidavit, you no longer have to do sworn affidavits now. You can just upload documents. You don't have to get a sworn with a commissioner. The third point, more cheaply, that's probably the most contentious point, because a lot of the disputes that I see, or I hear of at least even, are disputes that wouldn't have gone to court in the first place. These are disputes about records, for example, that the unit owner maybe wanted the records, but wouldn't be willing to go all the way to small claims court to actually get them, right? And so those kind of disputes before the CAT's creation just didn't come up, right? They would just give up the records requests, basically. Now you're finding a lot more condos are facing more records requests and records request disputes because it's so easy. You just log in online, pay the fee, which is, I think it's $50 or $20, I don't know. Chris probably has a better recollection of it from having done so yesterday, but basically it's a small fee and you basically just continue online. You don't have to do anything in person. It's just as easy as checking Facebook, basically, right? So those kind of disputes are now coming up when they wouldn't have. And of course, the legal fees that you'd have to pay a lawyer or a paralegal to represent the condo, those are, I would say, comparable in this disputes that I've seen. That they're not so much cheaper because the problem is the lawyer or the paralegal has to log in every day, check the messages, respond to the messages, do all of that work, when all that work would have really been done in one day in a full hearing, right? You really drag out the process of a one-day hearing over several days, sometimes every day. So I don't know if it's cheaper. As far as I know, not really, I'll say that. But it really is more efficient and more accessible. Maybe not cheaper though. And I guess the last thing that really comes up is in the records request scenarios, what we found is sometimes when a unit owner wants the records of another unit, right? If another unit owner is trying to get, I don't know, the arrears of his neighbor, does that neighbor have the right to then appear in the CAT, go online, log in on their own account, and tell the CAT, no, I don't want my neighbor finding out my arrears, basically. Now, before this expansion, the CAT really was a two-party system. It was the unit owner suing the condo. Those are the only two parties the system would even allow you to upload and name. Now, with the expansion, you can actually name another unit owner or basically any other third party to be involved in the same dispute. So now the question will become, can that unit owner come into the CAT and say, no, 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 I don't want my records disclosed to this unit owner. And with the CAT's expansion, it will also likely include, for example, the owner who lets his dog poop everywhere, or the person who stepped in that dog poop, to become a third party and be involved in the process as well. So that might actually be a good segue into Chris's experience yesterday of filing what may be the first parking dispute for the CAT.
Excellent. Thanks, Beck. And so, yeah, last night I figured, folks, that one of the best things I could do to prepare for our little talk today was to actually sit down and file a case in the CAT. I've got a commercial industrial condo client that has a dispute about tractor trailers being sort of parked on common elements in a way that blocks the loading docks of other units. So I figured this would be a good one. It would be a great learning experience for me, and I could share some of it with you, and I'm glad to do that. I have to be kind of careful about what I say about it, because it's very, very well, it's the lawyer stuff, you know. So but one thing I found as part of that process, and Vic hit some really good points in his what he just shared there, including that the CAT, of course, a major impetus in addition to it being accessible, cheap, and or cheaper, and accessible, cheap, and what was the third one, Maria?
Affordable.
Efficient.
Quick resolution.
Thank you. Quick resolution, yes. So I mean, to encourage parties to negotiate and to have a facilitated negotiation to settle these things, because most of these cases should settle. And the CAT process is front loaded to try to do everything where just the parties between themselves are doing this. And then, as Vic said, it graduates to the next step where you've got that professional to assist you. And hopefully these things can get resolved without decisions being made. And I think CAT statistics are that most of the cases actually, like very few of them actually go all the way to decision where there's no settlement. So in my case, in my parking case, I brought that as a compliance, as an enforcement. My client is seeking an enforcement, a compliance order at the end of it saying, don't park here, don't park here, don't park overnight, and don't park these kinds of things, that sort of stuff. And pay us for the lawyer's letter to warn you about this. So I sat down last night, and of course Vic said it's around the clock. So I was sitting in my civvies in front of my TV, just hammering this out around 9 o'clock at night, and entering the case that way, paying the $25 filing fee with a credit card. And that, it is very accessible. And mind you, because they have just started taking these cases, the interface needs some refinement. And they, as I'm used to entering cases online in Superior Court and Small Claims Court, this is a little bit new for me. And this is the first time I've ever filed a case in the CAT, because I've never assisted a unit owner making a case against the condo corporation. So now condo corporations, as you heard, can make these applications in their own way, and typically that will be for a compliance order, or for rulings in that way. So that was how I brought it. I was able to say it's a vehicle case, parking case, seeking a compliance with the documents. So I was able to check those boxes, and then I've got this one text box that says here you've got 3,000 characters. I thought it was like 10 times Twitter or something like that. and be as specific as possible about the case. So I used my legal training to say, the issue is this is what's happening. This is what the condo board is looking for. And hopefully that will get things rolling and get things started. And I uploaded the documents like the declaration, some drawings, the photos of trucks being parked everywhere, and of course the legal letter and maybe a copy of the bill saying here's what we want to recover back. And we'll see how this goes. But of course, and it took a long time to enter all that stuff too, because first I said, well, you know what, when all these times when I go suing unit owners, I don't necessarily need their email addresses or their phone numbers. So I found a lot of the data entry was a bit of a pain. And that's the kind of thing, like, we have to figure out eventually, how can we enter these cases more efficiently, more quickly? And of course, as we get used to it, we say, I need to have this information in advance. So the next case I do, I will know all the stuff that I need to have. I'll have it basically pre-prepared, and I will copy and paste it into the CAT webinar that way. Because the one thing is, for those of us who do this kind of work, whether it's managers or boards or their lawyers, cranking this stuff out and getting it in there quickly is going to be an important thing to help us get this stuff done. And of course, just when you recognize that if you've got like a 3,000 character limit for how to get the essential details of your case into the CAT, like, you've got to be pretty concise. You have to know what has to go in there, but to make sure there's enough there, but without there being too much there. So there's a learning curve. And so I had, it was educational for me to do that. And of course, we will all get some more experience with it, and we'll see what happens. But just before, so I don't leave you hanging, once I, paid with my credit card and got the thing filed, it says, okay, now the CAT will review your case. And if we think it's the kind of case we can take, we'll advance it, or you'll be advised about next step. And as of 12/21 today, I'm still waiting to hear. So
was there any indication of what the timeline is, like within a week or 2 weeks or anything?
I don't think it gave me any idea. It just basically said, sit tight and we'll get back to you, basically. So I'm hoping it's soon. I'll keep an eye on my email during the presentation here and see if it comes in during, between now and 1.
Excellent. It's always exciting, condo law. You know how that goes. Vic, so 2 things I'd really like to touch upon with our panel here. The first is, Vic, you said, the CAT perhaps opened the doors where complainants wouldn't be willing to go all the way, but now they are. Now with the expansion of the CAT to parking, pets, storage, indemnification, that statement, I think, is probably even louder than before. What do you think the ramifications will be?
Yeah, so I think basically one of the issues will be that every time a unit owner steps in dog poop, let's just say that as an example, right? He steps in dog poop and he goes, oh my God, my shoe, let me clean it off. And then what do I do to prevent this from happening again? And so that unit owner will now be able to, technically speaking, go online, like go home, wipe off the dog poop from his shoe, log in online on a smartphone, and file a case against the condo for failing to enforce against what I'm assuming will be a no pooping on the common elements rule, right? Mm-hmm. So it'll be very easy and almost, in my view, a little bit too easy for the unit owners to now bring their disputes against the condo corporation. Now, it'll be up to the CAT really at the screening process that Chris's case is in right now to basically have their front end staff to screen the applications and basically ask, have you complained about this before to the condo? Did the condo respond to you? And try and do those, good faith efforts to say, look, you can't just jump right to the CATs. I don't know if that's the case right now. I don't know if the front end staff of the CAT are trained for it. And that's why I think, to be honest, Chris, you might be waiting for a little while longer than most records requests for your response. But essentially what's going to happen is that we're going to get an influx of cases of people complaining about dog poop, someone parking in their parking units, someone storing something improper in their locker next door. So I think it will cause a wave of cases to come in now. And the result of that might also be that condo boards and managers themselves will be scared of actually enforcing those rules. So if, for example, the security guard sees the dog poop, sees them on camera, even gets DNA evidence, takes a sample of the dog poop, sends it to the poop lab in California or whatever, and gets a DNA trace that it is this exact unit owner. The condo board and the manager still have to make that judgment call. Do we want to risk it? Do we want to really charge back $40 or whatever for the dog poop cleanup and then risk having this unit owner file a huge CAT case against us for $40, because that's going to cost the condo way more in either legal fees, manager's time, board time, just energy even, than the $40 is worth. So every board and management company will have to start looking really closely before they actually enforce. Is it worth it? Do we have a good case? Which is, obviously everybody's concern at the beginning, but now it'll also be a cost benefit analysis. It'll have to be a risk analysis on, well, if we do this, we might be in the CAT for the next, 2 months or so. And the other concern that I think that especially we as lawyers, but also boards and managers should be having, is that now the CAT will be able to question whether your rule or your bylaw or your declaration is reasonable. So generally speaking, I'm sure the lawyers on the panel know, the rules and the bylaws have to be reasonable under the Condo Act. The declaration, not so much, but that's a whole other more complicated topic. But the rules, at least for sure, have to be reasonable. Now we have to look at, okay, yes, the guy, had his dog poop in the common elements, but is the rule itself against pooping on common elements reasonable, right? Like, do we have, I don't even know what the analysis would be, but do we have a pooping station with, bags for dog owners, all that kind of stuff? We have to start looking at the actual rule itself. So instead of just enforcing, instead of saying, okay, there's a rule, we got to enforce, we also have to look at, is that rule in the very beginning reasonably drafted? Is it a reasonable rule to go to the CAT for? And you know what, I will say this, right now with the CAT's records request disputes, reasonableness is already kind of an underlying theme. It's already kind of the gut feeling of these CAT members, is what the unit owner is asking for from the condo reasonable? So I think reasonableness, and this is the same in courts too, at the end of the day, it's all about whether the parties are being reasonable. We will have to see what the CAT will decide in its cases coming up, what that line of reasonableness looks like. So we're early days, but those are my preliminary concerns from the outset at least.
Yeah, and I would expect, Vic, that the line of reasonableness does change depending on the community, the corporation as well, and what is necessary at each property. So it's on a case-by-case basis as well. But Chris, what are your thoughts on this?
I agree with Victor. We're going to have to see sort of how things come out. And the other thing is, as when I was entering in that case, I saw there were boxes that you could click that say, oh, I have a problem with the validity of a rule. I have a problem with the reasonableness of the rule. So it could well be that when an owner receives a letter from the condo board or manager or the lawyer that says you have to stop doing this, someone can come back and say, you know what, your rule is not reasonable. You're inconsistent. You're applying it in an inconsistent way, or it's not reasonable to enforce it against me, or your rule is not valid for some reason. So like these are things that we might not have anticipated. But then again, CAT's got a broad mandate to say we can decide any issue related to rules and condo documents related to pets, to parking and to storage, and the indemnity for costs related to those things. So I think a lot of issues can be dealt with there. And there's some benefit, I think, to that. If, for instance, a board has passed a rule and owners say, we've got real serious concerns that this rule is valid. So whether the board is enforcing it or not, the owners might be able to make applications here to say, you know what, we don't think this rule is valid. Because, for instance, we didn't get notice, or we submitted a requisition, but there was no meeting, or it's invalid for some other way, or it's inconsistent with the Condo Act, the declaration or bylaws, or some other reason. So time will tell what comes out of this and exactly what the scope of this is. But I'm starting to think, I agree with Victor, that this could lead to a significant number of cases that come out. And I wonder what the impact of that is going to be on on the administrative end, the operations side, and on the management end of it. That's a big concern. I wonder what Michelle thinks of that.
Yeah, no, absolutely. Michelle, how does this all make you feel as a manager who works with boards and who routinely like to enforce and should be enforcing rules?
Yeah, it's I would say, I don't want to use the word like scary, but it is a little scary from a management perspective, because I mean, even the records request process, while it is great that there is a streamlined process, that process takes time, depending on what they were requesting. Does it have to be redacted? How do we have to access the files? There's time involved in that. So we're now expanding the amount of items that they can dispute. I do worry that it's going to bog down managers and boards' time. There's only so many hours in a day. We're already, management professionals are already very busy at what they do. So there's that concern. I worry about the abuse of it, like you've touched on, is I don't like this letter I received, so I'm going to go file a CAT dispute. Now, again, I'm hoping that the CAT has some sort of guidelines as to when to dismiss a frivolous claim and when to actually take it forward. But all of this is stuff we're going to be learning. So it's that uncertainty that we're facing that's a little bit worrisome from a management board perspective. But at the same time, I'm also interested to see the decisions which will provide us further guidance moving forward. And I think, again, just like, what we've been using it for to date, I think that a lot of guidance can be provided in that moving forward, they will be a more streamlined process. And I think it could be a great tool for corporations to use in order to efficiently settle disputes. So yeah, I think it's going to be interesting. I'm interested to see how it all plays out. I'm hoping it doesn't create a large additional workload, but we'll kind of have to see how that goes.
Yeah, it's kind of like a whole new area for us. You also mentioned earlier that with the CAT and record disputes, you started to do things a little bit perhaps more along the lines of having quorum, having minutes, having resolutions. How do you guys think that the expansion of the CAT will impact corporations governing documents, and what kind of responses or recommendations would you make in boards with those documents at this point? So for example,
no, I'll follow up. Go ahead, Maria.
So sorry, I was just giving, for example, the indemnification provision. So that's one thing that is that you can bring as a dispute to the CAT. Perhaps saying that a chargeback was inappropriate because the indemnification provision didn't allow for it. So what would you be working with your clients on to try to make sure that their documents are perhaps stronger and clearer? Because it is very likely that we're going to see an increased amount of disputes going to the CAT now. That's without doubt. My biggest concern has always been that it's going to be used as a sword instead of a shield, and that it'll be open to abuse by individuals who just, because it's accessible, because it's affordable, will use it more of a, I'm going to come after the condo just because. So there will be costs to the condo. So what can condos do, boards do, to better equip themselves to better respond to these kinds of issues, which will arise inevitably? Yeah,
that's a great point. Even since the Amlani case, I think that has already changed, or should be changing, the way that management and boards are already addressing these types of issues before the changes to the CAT, and now even more so. So boards, management, they need to be working together to review corporations' documents. If you are going to be doing an enforcement or a chargeback, in the past, I feel like we were just like, charge it back, charge it back, charge it back. And I think you really need to be reviewing that indemnification clause, because you are going to be challenged on that now. So if you are proceeding, you need to make sure that you're reviewing your documents in advance to make sure that if it is challenged in the CAT, the corporation can say, we reviewed it, we think that we are in line and we did things correctly. That being said, I know just from personal experience that a lot of these indemnification clauses are lacking. They are not substantial enough to charge back and cover what most corporations want to do. So you may be looking at increased declaration amendments to update those so that you can cover a broader scope of enforcement and chargeback issues. Unfortunately, there's obviously a cost, and that's amending a declaration is can be a little bit of legwork, but I think it's something that corporations are going to have to look at. Updating those 30, 40-year-old rule packages. We work with corporations that I go to pull up the rules and it's typewriter and you can barely even read it and it hasn't been updated since 1975. You need to be updating those because, again, your rules, like Chris and Victor alluded to, your rules could be challenged for reasonableness. So you really, I think, corporations, boards, management are going to need to take the time to review declaration, bylaws, and rules and make sure they have the right framework to move forward in kind of this new CAT world, so that if there are disputes coming in, they at least have the backbone to say, we got everything in line, so we can challenge this dispute and hopefully come out on the other side of it. So I think that's going to be a key component moving forward, is making sure that you're actively reviewing. And then if also you are implementing new rules, we work with boards that are like, put the rule in place, and they don't get a legal opinion on the reasonableness, or they really don't think future forward of how this rule is going to play out. Just more thought is going to have to be given into kind of all these different processes that we're already doing.
And if I can add to that, Michelle's quite right that as we get some experience with what CAT is doing and the decisions that come out, I think that very quickly is going to shape how, it's going to change how we do things. And just sending the letter out saying, okay, and here's this letter requiring you to stop, letting your dog roam the common elements. Here's a $300 chargeback, pay it. I mean, that will change. You may be able to support it by amending your condo documents, but we may not, and you may not. Some condos may not have the cards for that. So as we get the CAT's decisions on these things, for instance, there still is some lingering doubt there as to whether condo boards and managers have to distribute the owner's list when it's requested. That is now decisively and conclusively settled. And yet there still is some lingering doubt out there, and it will take time for managers and boards to say, well, we've been reading enough of the CAT decisions now. We know what is acceptable. We know what is the right thing to do. We know where we can win. We know how to win. And actually, more importantly, we know when and how to pick our battles. And not every hill is worth dying on, and not every fight is worth fighting. And condo boards are going to have a fair bit of flexibility, I would say, and they're going to have it to say, we're looking at this is a trifling non-compliance, or or we have to amend our rules to say, we need to clarify that or add some degree of reasonableness to it. So we will be, this is a process that's going to take a few years. Like, we're 3 years into the records piece, and those lessons are still trickling out, and it's going to be this way for, for pets, parking, and storage. And remember, to add on to Michelle's point, that of course, and as she said, the Condo Authority Tribunal will be taking on additional grounds of disputes. And one big one that has yet to come out, we've been saying that this should come into force now, is how condo corporations can do chargebacks, and not just about pets, parking, or storage stuff, but about anything. The Section 84 to the Condo Act, the amendments are there, they're on the books, but they're not yet in force. And that sets up the process for the condo board to say, okay, for us to pay our contractors to scoop up this dog poop that we trace back to you, it's a $25 charge. We're sending the owner a form. The owner can respond by taking a case to the CAT. And if they don't within the 30 days, they're liable to pay it. But if they do make that challenge, CAT decides it, or the parties settle it, and then it's done. So that's how these things will eventually go. And what that will bring, of course, is boards will say, is it really worth it to make a $25 or $50 chargeback? Like, if it's $1,000, okay. But if it's a puny one, like, just, that's part of the cost of doing business. And my final thing, and this is going to, Michelle might agree with me, is that the budgeting that condo boards do, like, you've got to build a little bit of leeway in for legals on this stuff. And the other thing is, you can't expect to recover every chargeback. I mean, you want to collect as many as you can to help stabilize your budget, but I mean, it's not always going to be possible or reasonable.
Yeah, very good points. We are getting some very good questions. We are reading them. Some we have been able to respond to, some we have not yet. We will try to get to as many as possible. One does jump out, and the question is, can you contract out of going to the CAT? What that means is, can the declaration say, regardless of whatever legislation is out there, whatever governmental orders, you don't have to go to the CAT. The board can just proceed as they wish. Can the condo documents, declaration, bylaws, or rules say that an owner doesn't have the right to go to a CAT, or that a dispute must be addressed in another manner?
So there's a really simple answer to that one, and it's no, because Section 176 of the Condo Act says the act applies despite any agreement to the contrary. So we cannot contract out of the Condo Act. Very sorry.
You also mentioned earlier, Chris, that submission of materials on the CAT is just uploading documents. Nothing has to be commissioned, notarized, anything like that. So what about the how good is that evidence? What weight will that evidence be given? I mean, I can just write up whatever the heck I want of an incident report, take a picture of that stage and say, look what happened. Where does the line start? What is actually good evidence? What is fabricated evidence? And how do you decipher it?
So
I'd ask Victor to weigh in on this
Yeah,
one. He's handled them.
I've had this situation arise. I'll say that. Yeah, that's going to be an issue because everything is online now. There are going to be cases with IT tech savvy people who are able to doctor images, doctor documents, and it's happened to me before where the unit owner doctored documents. And the issue will be is that the CAT's jurisdiction is on everything at first instance. So the facts, the law, how to apply that law to those facts. When you appeal the CAT to the Divisional Court of Ontario, the Divisional Court does not look at the facts. They say that the facts are settled. The facts are whatever the CAT decided the facts to be. So if the CAT was misled or if the CAT misapprehended the evidence that was given to them in an online portal in a PDF document, there's no recourse. And that's one of our main concerns is that there is no what we call a factual appeal, an appeal of the facts to the Divisional Court. And to be quite frank, the Divisional Court and many courts, as Chris alluded to, are backlogged with their own cases that are, I mean, to be frank, in the larger scheme of things, maybe more important to those, judges who are sitting there, right? Criminal cases, family cases of children, native rights, billion-dollar, multi-million-dollar Bay Street deals that are a little more pressing in the judge's mind than a condominium dispute. So a lot of them are very happy to let the CAT decide all the condo stuff and leave it out of the court system. So it's a huge concern. And every lawyer, manager, paralegal, board member, whoever's in the CAT will have to be on guard on both sides, right? If you're a unit owner, be on guard for fake evidence from the board. If you're a board member, be on guard for evidence that might be doctored from a unit owner. It's going to have to be a really forefront concern, especially because we can't see them in person, right? Sometimes you can tell when somebody's lying a little easier in person, or at least even by Zoom. In the CAT, it's all in writing. You don't see the person, you don't hear the person. There's really no way to test it unless you know for a fact, hey, that document has the wrong date on it. That's a Monday, not a Tuesday on December 6th, right? Like, that's the only way you're going to catch these things. And to be honest, in the cases I've seen, they were very tech savvy people. Even running a Photoshop trace wasn't going to catch it, kind of thing, right? It was we caught it other ways, but there are ways that can be, can dupe people nowadays, especially online.
Right. And, I guess maybe let's flip the dialogue a little bit and see from the perspective of an owner. We had a comment here about, well, maybe the expansion of the CAT will bring better governance into play and will give maybe owners a louder voice. So there obviously is some good to the CAT. Maybe we can discuss those points a little bit as well.
Sure. I'm just going to run really quickly through one of the cases that I am proud of because it was a unit owner case where basically the condo ignored ignored my records request, ignored the CAT order, ordering the condo to disclose these records, and I had to go to Superior Court to get those records. And I'm proud of that case because it really was efficient, it was fairly cheap, and it was accessible, right? That whole process was in, out, done, and it was probably way better than having to go to court at first instance. And instead of having to go to small claims court, get the small claims court order, which will take a year probably for the full trial, and then enforce that in Superior Court, I just went online, filed it, got it done. And hopefully that is bringing about some better governance in that condominium corporation. So it's a huge boon to unit owners who have a legitimate issue, and to be quite frank, who can pay a lawyer or a paralegal to really carry their case. Because at the end of the day, most lawyers know this, you're not going to get your legal costs back, right? So the unit owner really has to have that cash up front to really fund that litigation, to hold their board to account. But it is a good comment. It is a very, very good for the industry, I'll say this, for there to be a balance on both sides.
Yes, I think the balance is the key. Absolutely.
Let me weigh in on the issue of costs, because some of our attendees have asked about that too. Like right now, as it works, when you obtain compliance orders, our Condo Act is basically set out to say the condo corporation is entitled to recover its costs in in those proceedings. And we've got like the CAT's rules and the way the CAT's decisions are coming out is even where in those cases where Victor is completely victorious for his client, I mean, his client is not recovering the legal costs in the same way that in superior court. So right now there's this like, and condo lawyers and managers and boards are looking at this saying, you know, this is like, it's a Pyrrhic victory. Sure, we can go get our compliance order, or we can fight off a meritless request for records. But what do we pay for that? And we can't recover that in most cases. So, I mean, that's, of course, that's why the need for the better indemnification wording and declarations, but also like CAT eventually needs to, you know, see what's happening here. And if, for instance, recognizing condo corporations have a legal duty to enforce their documents. So you can say, well, sure, we can try to change our rules so that it doesn't happen. But when boards say, you know what, even though we've got a good violation here, or a violation that's worth us enforcing and getting a compliance order, we just can't afford it. Or our owners are going to freak if we take these steps and then we get our compliance order, but we make no recovery as to our costs. So, I mean, that's a big thing we're grappling with here. And it's not just, you know, this is not just for CAT and for the boards to grapple with, but I think we as lawyers need to look at this and say, like, we can't treat the CAT like we did superior court, where we can, you know, do all our things that the court requires, rack up multiple tens of thousands of dollars in legal bills, and expect that our clients are going to recover it, because the evidence is they will not. So how can we deliver that service in a better way, more quickly, more easily, more cheaply? Like, and we have to really think hard about it and figure out how can we crank this stuff out in a better way that's more economical and it gets a good result for a much lower price, because if our clients are not going to be able to recover all of it, they're going to expect and insist on a lower cost from their lawyers.
Absolutely. I think, you know, the one word that really resonates in all of our points here this afternoon is reasonableness. And that's on all accounts. I mean, I think we all have a condo or a client that has 60 pages of rules. You know, probably about 60% of them that they don't need to have because they don't apply, but they made them because they could. So how reasonable is it? And like Chris said, if you have a rule, you have a legal obligation to enforce it. I think now, I know personally myself as legal counsel, when management or board comes to me and says, you know, the person is, you know, in breach of this rule, I'll look at the rule and say, okay, 1, is it enforceable? 2, was it passed? 3, is it reasonable? 4, did that person actually breach it? Do we have evidence to show that they breached it? Because now I think, like Chris said, that cost consequences can get fairly high that you cannot get back from an owner or charge back against their unit. So I think that the threshold of enforcement is higher now to make sure that you kind of jump through all those hoops before you can actually say, yes, this is an enforceable, reasonable rule. The owner breached it. We can enforce it. But then also decide, is it worth trying to enforce it if I don't have an indemnification provision that allows me to charge it back? There's a lot of considerations now, I think, that maybe we should have been giving more, you know, consideration before as well, but we weren't forced to. So we're kind of reacting at this point in a lot of ways, I would say.
I think that hesitation is part of the purpose here, right? Like, I know the balance between unit owners and boards is really the key that I think even the CAO is trying to push for, right? To try and swing the pendulum in between the two, to make sure that boards are being very circumspect and really thinking about, do we enforce, instead of just sending out the chargeback letter without a thought, right? Like, I think that's part of the purpose, and I think that's, you know, laudable and commendable. But we just have to make sure that the pendulum doesn't swing too far, right? So I do want to get to the questions in the Q&A box, if that's okay with you guys. I know, Chris, you're lined up first to answer a 12:10 p.m. question. Do you want to do that live?
Sure, I can do that quickly. And the question there is, would it make sense to file cases against offenders by other owners or by the corporation? I get that sense. And Vic talked about the interveners, where you can have multiple parties involved in these cases, and you might have cases where unit owners are making cases and they want to have other owners involved. And you may have cases where the corporation says, well, we're making this case because we're getting complaints from this owner, and this owner, and they have a stake in this. And if they're happy, we're happy. So, I mean, when I was putting this parking case through the CAT last night, I was reading their policy on interveners and, you know, when it's appropriate to bring in other cases. And I'm thinking to myself, as Vic had pointed out, this can get awkward. This can get rather unwieldy where we got multiple parties involved in this thing. Some who may, you know, say, well, I'm just made the complaint. Condo Corporation, it's up to you. I haven't got time or interest to be involved in this. And actually what CAT's material said is when the corporation is making an application, they don't expect there to be any interveners. And to my mind, that's completely backwards. That's the case. That's exactly the case where you might want to have unit owners involved because the corporation is saying Mrs. Smith is complaining like crazy about, you know, the folks upstairs. And if Mrs. Smith isn't involved in this process in some way, like we wouldn't do it. We're not going to be here. So I think there's some tweaking that needs to be done. And I think that CAT's going to have some things to do. But to answer the question more specifically, I think it's fair ball for, and the system is set up for unit owners to make their own cases to the CAT against other owners or residents who are causing problems. And in those cases, the condo corporation will typically either I don't know if it's required or not. Vic, you might know if it's required that the condo corporation come in as an intervener. I would hope not. Because if some of these cases can be solved between owners directly, and I see Michelle nodding her head, she's saying, please leave the condo corporation out of this. I mean, we've got enough on our plate.
Yeah, when I just kind of management perspective, when I read that, you know, owner to owner disputes, kind of two thoughts. This could be great because as managers and boards, we know how, you know, we get the noise disputes, you know, above and below, they're just going at one another and no one's at fault here. And the corporation tries to intervene and it just seems like there's no resolution. So if those two can just kind of resolve it themselves, great. But at the same time, I have the worry of the two owners creating a case and then the corporation being dragged into it kind of unwillingly. So, you know, we might be, again, additional costs and time for something kind of out of our control. So I have the two perspectives of it. So it'll be interesting to see, again, how it goes.
Yeah, Chris, to answer your question, I remember you had red flag something in my mind. There is something in the rules of the CAT that say if you're an intervener, you have to give notice to the other people who are involved in the dispute. And most likely that rule is anticipating the future expansion of the CAT to noise disputes, odor disputes, all that stuff. So it is in the rules right now, though. So it is something that I think the CAT is thinking about, is really dragging the other parties in. Because again, they see themselves as very easy, efficient, cheap. They're saying, well, I mean, it's like checking Facebook, right? You have Facebook fights with your, you know, old uncle about Donald Trump on Facebook. Why can't you have an online CAT fight with your neighbor on the portal? So I think part of this is that they're trying to make it as broad as possible to try and capture the different viewpoints so that they can make an informed decision. Because again, even as lawyers, we don't live in the condo. We don't live in the unit with the noise or step in the dog poop. We don't know what's on the ground until you talk to the people on the ground. And I think that's what the CAT is really trying to get at, is trying to be almost inside people's units, right? Like it's online, you're doing it from your phone, you can take a photo, whatever, and then upload it. And I think that's eventually what they're trying to get at, is just that immediate accessibility.
So Vic and Chris, then just to clarify, what you're saying is that two owners can start, just so people who are listening have this clear. If two owners start something at the CAT can reach out to the condo and say, condo, come join this dispute. They can make them a party to it.
Yeah, there's a rule I'm looking at 15.3 of the CAT's rules of practice. If a unit owner brings it against another unit owner, they have to give notice to the condo corporation so that it invites them to the case to become an intervener.
Invites them or requires them?
It just says invites. It's an invitation. So you don't have to, but to be honest, if you're the condo corp, you really should, because most likely that CAT is going to rule on the validity or the reasonableness of your rule, which will not only apply to those two, it'll apply to your entire community.
And also it's interesting because if it's, let's say, a noise issue down the road, what if there's deficiencies to common elements and work has to actually be completed? So it's a much broader than just, I can hear a stereo, you know, through the wall. But yeah, so I think there's much more to come. Chris, I think you had a comment?
No, I was agreeing with what Vic was saying there. There are some interesting, I mean, the parts of with the intervener still, it is quite fuzzy, and I was concerned about that scenario where, say, there's a dispute between two owners where the condo corporation is not actively a party, and here's Kat going to decide on the validity or the reasonableness of a rule, and I'd say, yeah, that's the kind of thing the condo board would probably want to have a say about, and so this, and it might be, mind you, there's still residual discretion in the decision makers at CAT to say, you know what, if we are going to do that issue, and parties have to check the boxes when they're starting these cases. If that's going to be an issue, then yeah, maybe it ought to be mandatory that the condo corporation be a party to it. But it's a work in progress here, and we'll see how it plays out. But we have to watch that closely.
Absolutely. We have a question here. Will the CAT ever look at smoking / marijuana or cannabis issue complaints?
And the answer there is, yeah, they're going to be hearing a lot of different disputes over time. And of course, you know what, believe it or not, in December 2019, government put out, they were saying that was the next round of disputes they were going to put in. And we said, whoa, wait a minute here. We've got a lot of concerns about how CAT's going to do this. And if you're going to jump into this, into this sphere without us having that experience and understanding how it's going to work, like, for the love of God, start with chargebacks, start with pets, start with something else. And because those, I think, some of the chat and the Q&A we've seen, those are complicated cases. There's a lot of evidence there. It affects a lot of people. And until we figure out how CAT works and we get our feet wet with those kinds of disputes, it's a little too early for that. So yeah, we will be having smoke, nuisance, noise, all of that. That'll all be in CAT one day.
Absolutely. Victor, I was wondering if you had any more stories of experience at the CAT you could share that our viewers could take back to their corporations or managers, and that's kind of good lessons.
Sure. So one of the key lessons is, I think, even as a board member or as a property manager, you might have more experience with condominiums and even condominium law than the mediators or the CAT members who are in your case online. A lot of times what I find is half my job is teaching condo law to the mediators or the adjudicators. And that's in real court too. In regular court, you're going to have judges who have no idea what condo law is. I had a judge not know what the difference between a unit and a common element was and not care. It happens everywhere, but in the CAT, if, as Chris said, the whole purpose is to have a specialized tribunal with expertise in condo law, it's not there yet. And so in the next few years, we're going to have to make sure, as people from both ends, even as a unit owner, you're going to have to almost educate and highlight to the person who's hearing your case what the on-the-ground experience is like and what the condo law says. So a lot of this is really so new that a lot of us, even today, can't say for sure what's the best practices on how to litigate a CAT case, how to defend against a CAT case. It's really up in the air. And again, I always go back to the gut feel, right? Does this feel reasonable to you as a human being, right? And if your answer is no, then maybe you shouldn't be pursuing the case, right? So I think it really comes down to education of not just unit owners, board members, and managers, but also the CAT itself. And you have to be mindful of that. A lot of people I've seen self-reps go into the CAT thinking that the adjudicator or the member knows exactly what they're talking about, knows exactly how this condo is laid out and how the bedrooms are laid out and all that stuff. They don't. You have to teach them, and it's even harder to do in an online forum when you can't see the judge nodding or shaking his head or not writing anything down. It's harder for us to do as lawyers, managers, and board members. It's definitely harder to do as a unit owner. So everybody, I'm advising everybody, make sure you are able to teach the person who's in your case about the realities of your circumstances. And that's really the biggest takeaway I can tell anybody.
Thanks, Vic. Chris, Michelle, do you want to say anything?
I just had a quick question for the panel, and just because of the experience. I guess kind of just piggybacking what Victor was just saying was, do you think that there's always a need for corporations, I'm going to speak on behalf of management boards, corporations to have legal representation when dealing with these CAT cases? Do you think there is a space for boards to self-represent or have their manager self-represent? Or is there, stage 1, stage 2, boards can do it themselves, stage 3, engage your lawyer? Do you have any perspective on that?
Yeah, so I'll let Chris jump in. I know he wants to jump in, But just really quickly, yeah, most of the time with the records requests, I do say managers, you can do it. Stage 1 is negotiation, stage 2 is mediation. That's fine. But you have to remember, I'm telling you guys because I have the platform right now, as managers, do not forget to copy paste everything that went on in stage 2 mediation. Because when you give the case to us in stage 3, we cannot see stage 2. So if you have anything that went on in stage 2 that you want us to be aware of, you better save it separately. And I know for a fact the CAT itself does not produce that record. So if you want to appeal a CAT decision and you want the court to have that record, CHCT says we don't have that. We don't have stage 2 or stage 3 in our records. Too bad, so sad. So it's really incumbent upon you guys as users to copy paste everything out. And really, other than maybe records requests, I'm hesitant to say managers and boards sure self-represent, because as we said, noises, smoking, odors, even these parking vehicles, pets, storage issues, they're complicated. And so if you don't use legal counsel, at least have advice from legal counsel at the outset about how to do it, basically. They don't have to be there with you in the online portal, but get advice.
Victor raises a good point, and that is, you know what, you don't necessarily need the full-blown representation in these kinds of cases. I mean, CAT is set up so that it's intended that corporations can be represented by their managers or by the directors. And of course, you know, as lawyers, we always kind of cringe a little bit at that kind of thing. But when you look at the realities of the pricing model and the amount of work that needs to be done in these cases, and it's you know, as Victor described it, it's a whole lot of small little pieces scattered throughout the whole thing, rather than, you know, sit down for a day and work on the case. But I mean, having managers and boards having that coaching or getting the advice on the beginning, at least like to evaluate your case. And if you get a lawyer to look at it and say, you know what, that's a dog of a case, you better settle that somehow, or you've got no case here, just end it, or just don't bring it. Getting that kind of advice up front will probably really be of help. And then just, you know, having of course maybe in-house specialists to be able to tabulate that information. We get some statistics, we see what the CAT rules on in various cases, and that will give boards and managers and lawyers a lot more insight into how these cases are more likely to go. And eventually we'll get the artificial intelligence to predict how these cases are going to win. That's going to be the next big thing, I'm sure, one day.
I like, Chris, how you said use us as coaching at the very least, just to kind of guide you through the process. I mean, I think it's well intentioned, Michelle, and I think some managers absolutely could run with it to a large degree, as well as boards of directors. There's many qualified individuals out there. I think from legal perspective, it's just more of having the exposure to the issue on an ongoing basis that boards and managers may fortunately or unfortunately not have. Just like with the notices of liens and sending out those letters, making sure everyone has notice of it, who's on title. I know some management companies may prefer to do things like that on their own, but unfortunately, sometimes notices aren't sent out to everyone, and then that affects the process going down the road. So it's just making sure that the right steps are taken right from the forefront, so to better protect yourself and make sure you have a better chance of success down the road. I think that's the whole idea. Wow, lots to talk about. I feel like we could keep going, and odds are we will see each other again for part 2 to see how decisions have been made with the new CAT and the expansion. I'm sure I could have all of you volunteer to come back. It was great to see you guys today. So thank you for joining us today, Chris, Michelle, and Vic, for sharing your experiences and your thoughts. And thank you to everyone who was able to join us. Our upcoming events: if you are a CCI member, please join us tomorrow for the AGM at 3 p.m. We have the Professional Business Partners Committee hosting the major construction projects coming up on November 18th at 12:30. On November 3rd, we're hosting the Intro to Condos geared toward new condo owners and anyone who's interested in joining a board. You can register for all of these seminars and courses on our website. Again, please fill out your short survey and give us your feedback. We love to hear from you. We certainly try to tailor Condo Talks to your needs, to your wants. The idea here is to provide you with useful information. We hope you enjoyed today's Condo Talk, and we look forward to you joining us again sometime soon. Have a good afternoon.